Yes, Mr. Lightman, now we're moving on to ground 2, are we?
Yes, Your Ladyship. Now, in terms of ground 2, the original plea of the appellant as regard to its claim to be a creditor of the company was and this is in the additional bundle which has been handed up today, has the petition in its initial form. And I just want to...
Why are we going to that?
Just show how they put their case.
Why do we need to know that?
Well, maybe I'll just say
they
put their case purely as being a shareholder in the company. It was later amended to reflect the fact they weren't a shareholder in the company. Yep. They were in the sub fund. They were a shareholder in the fund.
And they've had to abandon company and
yes. So there wasn't
left now as association and sub fund.
But it wasn't on the basis that it was a creditor for any other reason. Its standing was simply on the basis that it being a shareholder. Now, it was then thought to be, and Mr. Spector, in support of that application, said at Spector 1, paragraph 24.2, which is page 75 of the bundle, there's a reasonable prospect of the winding up being of benefit to the petitioner and other investors in that it's essential that an independent liquidator be appointed to investigate the sub-fund affairs. So he didn't say there'd be any substantial recovery. It was simply that there would be...
I don't think that's ever been the case, is it? Hasn't it always been about investigation?
Well, that's how it was put, because the question is whether there's a likelihood of a recovery which would convert the appellant into a creditor. We say a creditor of a fund anyway.
Yep.
But is there the basis on which they sought winding up in the first place was there needs to be an investigation, not that there's going to be a recovery at the end of it. Then there was Justice Michael Green allowed the appeal against setting aside of permission to serve out, and he said that the inability to pay debts ground was he wasn't satisfied that it should be proceeded with. They then amended the petition to raise the issue of being a contingent creditor, which hadn't previously been pleaded. And they said the position was different from a general position of a shareholder in a company, which doesn't become a creditor of that company simply by reason of its investment, because of the possibility of a recovery. Now, in the appellant's skeleton argument for trial, perhaps if I could take you to one document, it's that supplemental bundle, volume 1, divider 1, page 13.
Sorry,
sorry.
am I in the wrong?
So divider 2, my apologies, page 13.
Thank you. Yes.
Paragraph 17. The petitioner seeks a thorough and independent investigation into the reasons for the sub-fund's failure and, where appropriate, claims made against those responsible. And again, at paragraph, the paragraph not only breaks down, but page 25.
Thank you.
Subparagraph 4. This is a case where a winding up order could bring a real financial benefit to the investors, and even if it does not, at the very least, at the end of a compulsory liquidation, investors should have a better understanding of how so much money came to be lost. And so the appellant didn't allege, let alone provide any evidence to show, that there were in fact any claims, or that any significant recoveries were the sub-fund to go into liquidation. And this was picked up by the Deputy ICC Judge in her judgment at paragraph 82. And she says at paragraph 81, in light of the above, the expert evidence about Luxembourg law. In order to establish its standing as a contingent creditor, the petitioner must by evidence satisfy the court, first, that the fund sub-fund has one or more claims, and secondly, that it's highly probable those claims will succeed. The problem in this case is that whilst there are clearly matters which require investigation, the petition does not and cannot go so far as to contend that it can be shown at this point in time that the sub-fund has claims, let alone claims that have a high probability of success. And then she quotes from the passage from Miss Hilliard's skeleton that I'd just taken you to. And she says, at 84, I cannot be satisfied on balance of probabilities that the petitioner, in its capacity as a shareholder, is a contingent creditor under Luxembourg law. I have to determine this matter on this point in time, at this point in time, and on the evidence being presented to me. And that, now the appellant's first appeal was principally on the basis of a contention that the ICC judge's conclusions lacked sufficient support from the expert evidence. And that was a contention which was rejected by Mr. Justice Richard Smith. He deals with this issue at paragraphs 76 and 77 of his judgment. You'll see the overarching submission was that the judge's conclusions were not sufficiently supported by expert evidence. So we're manifestly wrong in her related interpretation. So that's 76 and 77, and the judge rejected that appeal against that determination on that basis. Now, for this appeal, second appeal, appellant no longer seems to maintain that there was any error in the interpretation of expert evidence, but instead it says there's an error in failing to conclude that the appellant had demonstrated that the sub-fund had claims which were which it was highly probable would succeed. And what we say
why is the test highly probable? Just out of interest.
It goes back to the expert evidence about what is necessary to elevate a shareholder to a creditor under Luxembourg law. Perhaps I could take court to that evidence of that, okay, if that will assist. It's the wording of the expert report, the joint expert report. That's, I think, a document you haven't been taken to, the joint statement of the Luxembourg experts.
I'm 17.
At 17, and the first evidence is a joint experts report about so page 156. It says, bottom of the page, they may at certain times also acquire the status of creditors of a fund when they happen to own a claim against the fund which is certain and due. And they say, and then I think that's a basis, and then there's the further report of Ogier, where that language was picked up. It's at divider 18, and it's page 163.
Yeah, but that's, wait a minute, that's talking about when shareholders may become creditors of the fund when they have a claim to a distribution from the fund. I mean, that's just like saying in normal company law, you only have a debt when a dividend's declared. I mean, it's got nothing to do with whether the fund's got a claim against somebody else.
Well, that's how it was considered as being.
I just don't understand how
below.
Well,
but in any event,
I quite understand why, unless or until a shareholder has a claim due you can't claim to be a creditor.
Yes.
But doesn't say anything at all about whether there is a likelihood of recovery by the fund against anybody else. See, as I understood it, when Mr. Lewis was saying, and it didn't seem to be far from the mark, if I may say, if all the other creditors of the fund have been paid off, of the sub-fund have been paid off, which appears to be what we saw from the declaration we saw, any recovery will be available for distribution to C shareholders. So the question is it probable that there's going to be a recovery? But I don't understand where the highly probable comes from.
Yes. Well, I think I can rest on probable without taking it. No. Yes. Well, the paragraph 1.5.2 and 1.7 was understood to be relating to this question of contingent creditor. But I can see, my lord, that you are saying that that's in the context of a direct claim by a creditor as opposed to a claim by the company.
You really don't need the adverb anyway, do you?
Yes.
I mean,
Well,
probable, what would suit you fine.
Yes. Well, I won't. As I will rest with the joint report for in general. But the point is this: the the appellant has failed to identify any specific claims which either the fund or, for that matter, the sub-fund, or we say the fund wouldn't have any claims, against any particular person or persons, let alone any claims that have a high probability of success. The sub-fund's been liquidated and there are no remaining assets. The appellant has failed to show how a liquidator would even have the resources to investigate or pursue any claims, or any basis on which they would have any likelihood of making any recovery, whether of legal costs or otherwise, from any third parties. And so we say that the appellant has failed to demonstrate, and the onus is on the appellant, that it is a contingent creditor within the meaning of section 124 of the Insolvency Act.
They just say to you, well, where's the money gone?
But we say that's not enough to elevate them to the status of a creditor.
So you can just keep quiet, say nothing, and that's it. They can't do anything about it.
I'm not aware of letters they've sent to any particular people in respect of any potential claims. But what we say is that if they have to go beyond, and as I said, they started off on the basis that there needs to be an investigation, not that there'd be any recovery. That was what they wanted. Then for them now to say, well, actually, there is a recovery which will be made, or likely to be made, on liquidation, is entirely speculative. And we say that's not a sufficient basis for this court to overturn the decision of Mr. Justice Richard Smith. Appeal to him was again on a limited basis from the finding of the Deputy ICC Judge after a trial of the petition. But the second point is that they have to show that they are a contingent creditor of the sub-fund and not of the fund. And this goes back to the point about them being a shareholder in the fund and not a sub-fund. And both the ICC Judge at 44.1 and in turn Mr. Justice Richard Smith at 65 concluded that as a matter of form and substance, investors were shareholders in a fund and not in a sub-fund, and we say that they were right to so conclude.
So there are 2 points. You say, first of all, they can't show that there's any likelihood of recovery in relation to the sub-fund by anybody. And then secondly, you say that even if there was, that wouldn't make them creditors of this sub-fund.
Yes. What the way that, so they have to get over both hurdles, and what the appellant suggests in dealing with this second hurdle in their skeleton is, and this is paragraph 60, although it's accepted that the judge accepted the deputy ICC judge's finding that in circumstances where the surplus, the shareholder would have a claim against the fund rather than sub-fund, that is a matter of form rather than substance. The shareholder rights being against a surplus and sub-fund only, so the appellant can fairly be described as a contingent creditor of the sub-fund. That's in brackets at the end of paragraph 60. Now, they have to, we say that that argument is unsupported by fact, law, or practical logic. It's unsupported by any expert evidence either. And it's put in there with brackets at the end, but it's actually the key to their standing as a contingent creditor. They would have to say they should be fairly described as a contingent creditor, i.e., for the purposes of section 124 of the Insolvency Act, the appellant is a contingent creditor of the sub-fund, even if there were a claim out there. And we say that goes entirely against the expert evidence that the shareholder of a fund, this is page 156, the joint report. So the experts agree that the investors in a dedicated fund are primarily shareholders of a fund, but they may nevertheless also become creditors of the same upon occurrence of certain specific events. And the jump they then have to try and make from shareholder of a fund to a creditor of a sub-fund, it can't be achieved simply by saying fairly described as, or a substance of matter substance form rather than substance. It goes to the locus standi to petition, the position of somebody as a contingent creditor, not a contingent creditor in the ether, but a contingent creditor of the sub-fund. I don't know if there's any more. I insist you on ground 2, and I'll move on to ground 3. Now, ground 3 is an argument that wasn't run before the judge. It was not run as a separate freestanding argument before Richard Smith J. It was part of a section of a skeleton argument concerning the appellant standing as a contingent creditor. It was dealt with by Mr. Justice Richard Smith in his judgment on not on a detailed examination of the jurisprudence, but purely on the basis, perhaps I'll go to that at paragraph 82. Of his judgment. The argument, despite the appellant's concerns about the conduct of liquidation sub-fund, I found this argument unpersuasive. There was scant evidence before me or the judge concerning the adequacy or otherwise of available remedies to the appellant. For example, as to the regulatory action that might have been pursued locally by the appellant, or steps that could be taken against the fund itself, and therefore no sound basis for me to say that such exceptional circumstances were present in this case. So before we go into the interesting issues of law about exceptional circumstances, the judge dealt with it on this only being raised on appeal for him, that there was scant evidence that really there was what they would be without effective remedy, and he had pointed out earlier in his judgment that they could have presented a petition against the fund.
But assume for a minute, forget about the complications of a fund. If you've got a foreign company which has taken investments in from members of the public in the UK, and the money has disappeared without any explanation being offered, why do you say that the English court couldn't consider that an investigation in those unusual, exceptional circumstances would justify making a winding up order, assuming that it's, for this purpose, clearly an overseas company within 220?
Well, Well, Lord, the issue that arises, and it was considered in the GFN judgment of Justice Appeal Voss, is you have a locus standi requirement for being able to obtain a winding up order, which has to be respected and has to be complied with. There are two issues: whether the court can determine a dispute in the petition proceedings, or must dismiss the petition without doing so, or whether it decides to wind up a company without even deciding whether somebody has locus standi. And what we say is, in this case, they're not suggesting, for example, that the judge should have found they had an arguable case, or that they satisfied the burden for winding up. They're saying the court should just make a winding up order without determining that the petitioner had standing to petition.
But if the petitioner, without discussing, if the petitioner is clearly either a creditor or will become a creditor, a contingent creditor, or is entitled to a distribution of assets as a shareholder, whichever way that they have an interest, call them an investor if you will, and the circumstances of the failure of the company cry out for investigation. You saying that because the court can't make a winding up order because it can't identify in it ahead of time whether the person is either a contingent creditor or a shareholder, even though there's nobody else who's interested in the company.
Well, what we say is the question is, is there a carve out, any carve out, first of all, for a general principle, and the second question is, what is the extent of that potential carve out? Can I take your court just to one authority in the new authorities one, which we say addresses a situation relatively, in some ways similar to ours, which is the case of Baker Hughes. It's only one paragraph from that judgment. It's at Divider 6. And I just invite the court to read paragraph 10.
Thank you.
So the first bit of that is contrary to English law and binding Court of Appeal authority. And the second bit admits of the possibility of making a winding up order in an exceptional case. The reason I say the first bit is is contrary to binding Court of Appeal authority is because there was a decision of this court about a year ago, perhaps a little more, myself and Lord Justice Newgee amongst others. The question of whether there is a dispute as to the status of a creditor doesn't mean that the person isn't a creditor. They may be. It's just that as a matter of practice, the company's court won't resolve the dispute, but will send you off to the ordinary courts to establish your claim. But it's a matter of practice, not a matter of jurisdiction. So when Lady Smith says, if the debt is disputed in good faith on real and substantial grounds, then the creditor cannot satisfy the statutory requirement they're a creditor. That's, as I understood the decision I was party to, that's not English law. It's just a question of practice that we don't allow a disputed status as a creditor to be established in a winding up proceeding. And then the second bit is Russian and English Bank, which says, but there's an exceptional, if there's an exceptional case, you can make a winding up order. So,
well, if there is room for departure, that's how I should put it. But I think maybe I should clarify. But the case which I principally rely upon has been the decision of Cayman Court of Appeal, and in that case, it is clear that it's.
well, do you want to
It's
show?
a matter of general rule of practice, as opposed to.
Let's look at that then.
So perhaps we should look. In fact, perhaps we look at that. It's only a few pages at the end of the analysis there, which the point I was really trying to make from the judgment of the Smith judgment is that, well, Russian Bank is a case of some antiquity, and here the exceptionality. Here, there, it was. As we say the same as there. Possibility of assets being restored, vague, provisional, general terms, and we say that that's factually where we are here. But looking at the legal issue, and I'm afraid I wasn't aware of the Lordship's judgment.
Well, it's in a bankruptcy case. I'll try and find it in a second, but it's setting aside of a bank statutory remanded. Sorry, I think it's an attempt to strike out a bankruptcy petition, but the question was the same point. What do you do if there's a bona fide insubstantial dispute? And the argument was, well, if there is a bona fide insubstantial dispute, you're not a creditor, therefore you haven't got jurisdiction. The court has no jurisdiction, it was said, to make a bankruptcy order. And I'm pretty sure we held that actually that isn't what the law is, that you may be a creditor, it's just the law doesn't allow you to establish that. Yes. in the Insolvency and Companies Court. You're sent off as a matter of practice, yes, to the normal courts to establish your claim. But it's a matter of practice, not of jurisdiction. That I understand to be English law. I'm open to be corrected, but
perhaps we'll see how it's put by.
How is it put in
this? I won't tell. We will start at paragraph 94, if we may, page 685.
What are we looking at? GFN?
Of the yes, which is
where
divided to 11.
That?
Divided to 11 of the main authorities bundle, please. The thick one.
Thank you.
Paragraph 94, having looked at the authorities, Lord Justice Appeal Voss says, he summarizes principles, person with a good arguable case can present a petition. Normal rule of practice is it will dismiss or stay a petition where there's a bona fide dispute. In an appropriate case, the court can determine the question of dispute in the petition itself. For example, where the creditor...
I'm so sorry. We're on page...
685. Paragraph 94.
Thank you. Sidelined person.
Where the creditor, if established there, would otherwise lose his remedy altogether, or where other injustice might result. That's when the court would determine the question of a disputed debt. E, where the winding up court decides to hear a petition based on disputed debt, it will only make a winding up order on the grounds it's unable to pay its debts or just unable to wind up, having determined that the petitioner is, on a balance of probabilities, a creditor of a company. The trilogy of Russian bank cases may constitute a single legitimate exception to that paragraph E, but beyond the scope of its judgment to express a concluded view on the correctness of those decisions. So the way that I read E is that the court will not make a winding up order unless it's determined that the petitioner is, on a balance of probabilities, a creditor of the company.
Right, well, I don't think it's actually inconsistent with the way I put it to you. I mean, the court will have to investigate whether a person is a creditor, i.e. entitled to benefit from the winding up in order to invoke the collective remedy.
Yes.
I sort of understand that. The rest of it is a rule of practice. It doesn't...
Yes.
I think Lady Smith went a little further than that. If I read her judgment, she was saying if there's a dispute, you can't present.
Oh, well, that I wouldn't. But in fact, I must have. That's not the basis on which. That's taking it a bit further than I would.
I thought that's what she said, but
title to sue. I think it's her use of alert so to have title to sue in a petition for winding up. And that's a different point because it's clear from paragraph 1, A of 94, the petition person of a good arguable case may present the petition. There's a distinction between a good arguable case to present, then there's a balance of probabilities that you're a creditor in order to get a winding up order later.
I mean, you have to say, I'm a creditor. Company comes back and says, no, you're not. The court then assesses, is there a good or a genuine dispute? Sorry, is there a bona fide dispute about that? A genuine dispute, let's say, a dispute on substantial grounds. If yes, then the court has the discretion. In the normal course of events, it sends the parties away from the winding up court and says, sort it out in the normal courts. Don't come back here until you've done it.
Yes.
But it can say, no, actually, we can determine the dispute here and now. You say that's what this says.
Yeah.
If then you are to get a winding up order, you have to be a creditor.
Yes.
You've got to establish on the balance of probabilities you are a creditor.
Yes.
You could establish on the balance of probabilities as well that you are a shareholder who would also be entitled to seek a winding up of the company.
Yes.
Couldn't you?
Yeah, well, of course, in this case, what we say is they have to show that they are a creditor of the sub-fund.
That's the different point. That's your second point. That's they've got the wrong target.
Yes.
But just on the first point,
yes,
if they could show that they were either a contingent creditor or a shareholder and they would have a potential benefit from a winding up in whatever capacity you might call it, why would they not be entitled to winding up order, assuming that they've got the correct target?
That's section 124. That's the locker standi. One of the basic elements of petition is that you are a contributory.
And you say that there's no jurisdiction to wind up a foreign an overseas company on the just and equitable grounds.
Well, it's in paragraph 124, which is from part 4, but applies to part 5, as we saw. An application to court for winding up of a company shall be by petition presented either by the company or the directors, this is divider 16 of the authority funnel, or by any creditor or creditors, including any contingent or prospective creditor or creditors, contributory or contributories. So that's a contributory of that company.
Yeah, of that company.
And that's why...
I understand the of that company point.
Yes, which is why that's the basis on which they could have presented a petition in respect of the fund.
And you say they may be a member, but they're not a contributory.
Well, they're not a contributory of the sub-fund.
No, I understand.
Yeah.
Sorry,
yes,
I'm just focusing on the... Assume against yourself, for the present purposes, that they could establish their status in relation to the sub-fund.
Yes.
See, I think you're taking 2 points to understand.
Yes.
One is they don't have the relevant lockers. And the second is, even if they did, it was against the wrong thing.
Yes, I mean, what I'm careful to do is I'm not aware of evidence as to whether or not they are a contributory of the fund. It may be my learned friend my junior will tell me there is. I don't want to go further than the expert evidence went. It's not something I've particularly focused on. So that's why I'm being a bit cautious in responding, because I don't want to go further than the evidence would allow me to.
Yes, because curiously, my very rudimentary understanding of this section always sort of just had in my head, you could get the winding up if you're either a creditor or including a contingent creditor or a member. But in fact, you point out it's contributory, and this is one of those rare situations where you say that even if they were a member in the sense of being a shareholder, they're not a contributory, therefore they can't use it.
Well, I've said they're not a contributory of a sub-fund. I haven't...
No,
Sorry.
I know the second point is it's the wrong
Yes.
fund or sub-fund, but just put that one to one.
Sorry.
I'm trying to just deal with your first point.
Sorry.
About status.
Yes.
You're getting a message.
I tried to see if there is anything that helps me.
Yeah.
Sorry, my lord. I on status, in wording is contributory. And that has a particular meaning. We've seen the meaning. The meaning in section 124 is the meaning from section 74, section 79, and so yes, it's limited in that way. If you were a member but you weren't a contributory, then you wouldn't have locus standi as a contributor, within that category to petition. So it's divider 16 has 124. I'm sorry that all the different bits of statute aren't in one place.
Now, where do we go from there?
So that was 94. I just wanted a little bit more, if we could, on this judgment. He does talk about, because my learned friend relies on the Russian, or has in his supplemental skeleton relied on the Russian bank cases as being a source of the exception. And I just wanted to see what Justice Appeal Voss said at 96. He said at page 686. I should say a third word about cases urged upon their supporting proposing view. First, the Russian bank cases were very special situations in which unregistered companies were wound up on the ground that they had been dissolved. The reason in each case seems to be that the disputed debt could not be sued outside the winding up court because the company had already been dissolved. I don't think that these cases can be a precedent affecting the ordinary winding up situation where a petition is presented by a creditor with a disputed debt. He then it refers also to Deloitte and Touche, where Lord Millett said, halfway through the quote, wherever the court is asked to exercise a statutory power in its inherent jurisdiction, it will act only by the application of a party with sufficient interest to make it. This is not a matter of jurisdiction, a matter of judicial restraint. And he then concludes at 100 that despite some cases that are not wholly explicable, a reasonably consistent picture has emerged. And he says, I accept there's a real argument as to whether the legislature could have intended a creditor to be permitted to proceed to obtain a winding up order on the ground set out without establishing his standing as a creditor. And he explains why. He says, but ultimately I've concluded this cannot be correct. The court cannot wind up a company at the behest of, I think the word at a should be added, creditor, without proof that his debt is on a balance of probability actually due and owing, because there are then 4 reasons given. The first one is having collective execution at the behest of someone has no legitimate interest in the affairs of the company. Legislators laid down specific people who can petition, and one would expect a creditor to establish his status before any final order is made. If he could do so without establishing his debt, companies would be at greater risk and have less protection from those wishing to damage them than the legislator can, it seems to me, possibly intended. And they said, authorities provide no significant support for proposition. Winding up order can be made without petitioning creditor establishing his standing as a creditor.
Yeah, I mean, this is all said in the context of somebody who is only capable of being a creditor, was it? I mean, this is a bank.
Yes.
Sorry, this is a respondent petitioner in the solvent Cayman Bank sought the winding up of the appellant company in respect of an overdraft. Right. So this is there's no question here that the petitioner could have had an interest in the collective process of execution by reason of being somebody who would benefit from a distribution in the winding up. I mean, it was only creditors. I mean, if you look at what's said in 101A, it would be remarkable if the court was prepared to exercise a statutory jurisdiction to put in effect a process of collective execution against the assets of the company for the benefit of all creditors at the behest of someone who had no legitimate interest in the affairs of the company. But if, for example, a shareholder, I'll be neutral for a second, try and avoid the contributory question, if a shareholder who would benefit from a distribution of surplus assets in a winding up made the application, then why would the court, I mean, the court wouldn't be acting in a way that was winding up the company with the benefit of somebody who had no interest. What I'm trying to get to is that it's difficult to understand why the petitioner in our current case isn't somebody who either is a contingent creditor or a shareholder entitled to participate in some surplus, if any. I appreciate there's a question about if any, but they're not disinterested in the affairs of this company, to use Mr. Justice, Lord Justice Voss, or whatever he was, Justice Voss's word. I mean, yes. You're not suggesting that Mr. Lewis's clients are disinterested in the affairs of this company?
They may have some non-legal interest, but they are not a party which can obtain a winding up order. And that's where the courts have limited the availability of a winding up order to parties who satisfy the Section 124 jurisdiction test.
So it all turns on the nature of the meaning of the word contributory.
Yes.
In fact, in a sense, you say they're not a contingent creditor because they can't show a likelihood of actual money being owed to them. They're not a contributor because nobody suggested they're due to contribute to the assets. And it doesn't say shareholder, therefore they're just outside the statutory scheme altogether.
Yes, we say that otherwise it would create a great degree of uncertainty if the courts would decide to broaden the availability of a winding up order to parties which had not been specified in Section 124. That would be a form of judicial legislation.
So, are we actually going to look at the Russian company cases?
We can do so. I'm happy to do so. Perhaps yes, the one which is in the bundle is at Divider 3. Now, that was a decision of Mr. Justice Bennett. Now, the petition was for the winding up of a Russian and English bank presented by 3 persons claiming to be creditors, the sum of £20,000. That's page 664. Now, there was, you'll see at page 665, opposition from other creditors. And Lionel Cohen, KC, represented them. They support the contention as to the jurisdiction, but oppose the petition on the ground that the debt of the petitioners is a disputed debt, and they're therefore not entitled to present a petition for winding up the company. They presented their own petition, and you'll see at footnote 3, His Lordship dismissed the second petition on the ground that petitioners therein might, in view of the attitude which they'd taken up, had been given notice to appear in support of her petition, and if necessary, have been asked to be substituted as petitioners. So you have a situation here where there were creditors before the court. There was a disputed debt in respect of the petitioner. Now, at page 669, Mr. Justice Bennett said, in considering what was the intention of Parliament, it seems to be material to consider what course the courts of this country had adopted shortly before the Act of 1929 came into operation with regard to the position of Russian corporations under the various decrees made by the Russian government. And he even quotes from Lord Sumner in the Employees' Liability Assurance case. The Lordship decided last year that the decrees of the Soviet government of Russia, which then were textually before you, did not, in the case of banking companies, dissolve the companies themselves, but only stripped them of their assets and destroyed their goodwill by making banking a state monopoly, while at the same time they deprived the shareholders of their shares. In those decrees, not only the word dissolution, but the thing itself was carefully avoided. So there's a particular event which had occurred, which led to a number of banking cases, and it also led, incidentally, to the what is now Section 225 of the Insolvency Act being added to the canon. It was about a question of so that's where that comes from. It comes from these particular circumstances. What was described as exceptional circumstances. You'll see at page 670. There's no doubt as to the general rule that disputed debt may not be the basis of a creditor's petition, but the position of the petitioners in question is a singular one. So it's a singular situation They brought their action in 1927 for the purpose of establishing a debt, but having regard to a decision in the Baring Brothers case, have no longer any existence. The bank no longer has any existence. It's not possible for them to proceed without action. In the circumstances, they'll be without a remedy unless they can proceed by way of a winding up petition. The mere fact there's an order on petition will not establish their creditors, due to the liquidators to find out the rights of petition creditors unless they reject their claim. It does not seem to me that the general rule against a disputed debt being used as the foundation of a winding up petition should be applied in the present case, where the persons whose debt is disputed would otherwise be without redress. In the circumstances, no possible harm can be done to anyone by winding up being order made, and as the creditors who oppose the winding up on this petition are themselves desirous that the company should be wound up, I overrule their objection and make an order on the petition. So you have a situation where there were other shareholders, other creditors who plainly were undisputed creditors. There was a disputed debt where the petitioners had already issued proceedings in 1927. But because of the impact of the ruling in the Baring Brothers case, they can't proceed with that action. They would be without a remedy in respect of this company. It's a company would be, and where the winding up order could have been made on the second petition. In those very particular circumstances.
But if your submission is right, this case is wrong.
Well, what I'm saying is, well, first of all,
if your submission is right,
yes,
this company could not be wound up in England under any circumstances because it has ceased to exist under the law of its incorporation, and therefore, ergo, it does not have any members, contributories, or creditors.
Well, there were creditors.
Well, how can they be if the company ceased to exist?
Well, Section 225.
But you say it doesn't matter about 225 because you say there is a prior, that just sets out the circumstances in which an unregistered company may be wound up. You're saying there is a prior requirement, which is that you have to have somebody with locus standi to ask the court to invoke that power. And you say there is no such person. And I'm saying, well, if that's right, where was the person in this case?
Well, we say there were other creditors.
How could they be?
Because it was the jurisdiction was provided.
Everybody seems to have ignored the fact that if the company ceased to exist, you can't have creditors. They just assume that the status of creditor continues for the purpose of locus standi.
Yes, because otherwise, so Section 125. What? Oh, is it? Well, the other Russian bank case, the next one, it was clearly, that was also based on, I think it has its, this is the other Russian bank case is at Divider 4, it has the statute in it, at page 414. This was section 3382. Section 3381D, unregistered company may be wound up if the company is dissolved. And 2, where a company incorporated outside Great Britain, which had been carrying on business in Great Britain, ceases to carry on business in Great Britain, may be wound up as an unregistered company, notwithstanding that it's been dissolved, or otherwise cease to exist as a company under or by virtue of the laws of the country in which it was incorporated.
Yeah, but again, in fact, the statute, which is now the predecessor of section 221, subsection 5, was already in existence when these cases were decided. As you can see that, it came in originally in 1929.
Yes.
But it doesn't seem to have stopped the court invoking the power under what is now section 2215 to wind up the company on the basis of either A or C, that on the face of it, there is difficult to see how it could have somebody who actually said I'm a creditor because the company ceased to exist, or indeed that there was a dispute. I mean, the court seems to have said, I don't care whether there's a dispute, which, as I say, I don't think actually goes to jurisdiction, but there's a rule of procedure, more recent authorities suggest, nor the fact that it actually has ceased to exist means that the court can't exercise its power. So I sort of suggest again, what is the test of standing under 2215 really a question of whether there is somebody who has an interest in the winding up process?
My Lord, I go back to what Section 124 provides. It may be that the use of the word creditor goes back to the position as it might have been prior to dissolution, or if it hadn't been dissolved. But I don't think there's warrant to because the company's been dissolved, to then create a new category. That wasn't what happened when Section 332 was enacted. And it was clearly in respect of a company which had dissolved. There was no relaxing of this locus standi requirement.
So you're saying that in order to invoke 2215, you have to be somebody who
was a
creditor or a shareholder
or contributory.
Was a creditor or contributory prior to the dissolution of the company.
Yes, because there has to be some. Well, that's a statutory requirement. There's no other way in which one can see a. But that's the gateway to present a petition. That may have to be interpreted in the context of a company having been dissolved, but one can't tinker with it and come up with some sort of new category which the statute has not laid down. I don't know if there's anything further on. I wanted to say a little bit more about two things on this ground, but the first one is Russian bank cases involved. We say if Mr. Lord Justice Appeal Voss said he wasn't going to say anything about the correctness of that decision. He certainly wasn't going to endorse it. They were singular cases. What I say is that they don't, in any sense, override the sort of cases which have, many cases which have set out the general principle over the last almost 100 years. It would create a lot of uncertainty in the law. Where if a court of appeal now were to apply Bennett J in that case in preference to all the jurisprudence going forward, including Mann and Goldstein and all the other authorities referred to by Justice Appeal Voss, then that would be quite a radical development. And it's this is not a case which justifies that. This is the Russian bank case. At least was a company. It was a company. Here, the sub-fund is not incorporated. It has no legal personality for purposes of the law of Luxembourg. The appellant's asking the court to exercise the supposed exceptional jurisdiction in circumstances where it cannot establish that it has any sufficient, it has standing as a creditor of the sub-fund at all. It simply wants the liquidator to undertake an investigation. It's not a case where the petitioner would otherwise have been, in the words of Bennett J., without redress. He could have presented a petition against the fund, of which it indubitably was a a shareholder. If, contrary to my submissions, the court has discretion to wind up an entity where there appears to be a bona fide dispute on substantial grounds, those circumstances would be wholly exceptional, and Richard Smith J was entitled to give weight to the lack of evidence from the appellant as to, and I quote from Power 82 of the judgment, the adequacy or otherwise of available remedies to the appellant, for example, as to the regulatory action that might have been pursued locally by the appellant, or steps that could be taken against the fund itself. So on the facts, they'd have to also disturb his factual determination, as well as establishing satisfying thought about the law. And as Richard Smith J noted at Power 70 of his judgment, the court clearly has jurisdiction to wind up the fund as an unregistered company under Section 2201 without many of the confounding factors described that would arise in the same context of a sub-fund. That's at page 83 of the bundle. If my learned friend is seeking to sort of say that somehow dissolution is the key element of this, then I would be wanting to take what I know has been described as a pleading point, but this petition has not been presented on the grounds that the company had been dissolved. And it specifically was not put on that basis. It's put on the basis that it ceased to carry on business or carry on business for the purpose of winding up of affairs. And indeed, if a transcript of a hearing, perhaps I could just briefly take you to this just for a minute.
Why couldn't the petition, if all other things were equal, why couldn't the petition be amended?
Well, it could be amended now, but...
Because you accept that the company's been dissolved.
Accept it's been dissolved, but then the question is whether that's... It was specifically... Mr. Lexa Hilliard specifically said, we're not proceeding on that basis, on that ground.
Did they know at the time that it had been dissolved?
Well, it's the same situation. Nothing new has happened. Perhaps I can just take...
Well, they found out that it's been dissolved because you told them.
Can I just, on that point, I did want to take you to where the evidence was on that point, because you did ask me a question previously about the wording of the letter, and I want to respond on that, but also show you this. This is the supplemental bundle. Second witness statement of Mr. Harvey, that's divider 14. It's dated the 23rd of August 2021. And I just invite your ladyships and your lordship to go to page 118, paragraph 10. And he says this: shares are issued in a fund and investors have a vote at company level, i.e. the fund. There are no share certificates, but the fund has a share register. The fund has different classes of share, with such classes relating to the sub-funds. Therefore, although the petitioning creditor's shares related to the sub-fund, the petitioning creditor was a shareholder in the fund. And this is the important sentence, my lord. The petitioning creditor is no longer a shareholder, as all the shares in the sub-fund were redeemed at the end of the liquidation process. That's a witness statement made on 25th of August 2021. All that's said in this letter is explaining why they were not given notice of the meeting in October.
And that's because it related to the fund, not the sub-fund.
So, well, this is not sort of what was in the letter wasn't totally new information. And the issue of if there was, it's not as if the issue of dissolution wasn't clearly before the court, because Lex Hilliard, and I just want to very quickly take you to the transcript. It's only a couple of pages in a new supplemental bundle.
Well, the fact that the fund had been liquidated was completely new and only discovered a couple of days ago.
Certainly. The point I'm looking at is the dissolution of a sub-fund.
For my own part, and I speak only for myself, I do find they don't have the shares anymore. So even though we're up to our armpits in litigation, you didn't need to know. I find difficult.
Well, I hear what your ladyship has to say. I'm afraid I can't say anything informative about that. But if we go to divider 2, that is a transcript of the new bundle, which has been had up this morning.
Thank you.
The first page, we put underlining by relevant parts.
Well, could we just put this in context?
Yes.
Who's saying what to whom?
Yes, this is Lexa Hilliard KC, the transcript of the first day of a trial of the petition before the Deputy ICC Judge. Sorry, that's not apparent from that first page. And this is Ms. Hilliard speaking, and she says that G, the petitioner's case it's an unregistered company for purposes of sections 220 and 221 of the Act. She said, on the grounds and jurisdiction, the grounds on which winding up are companies cease to carry on business, etc. And next page, it is, and I'll come to it later, Judge, not being sought on the basis sub-fund has been dissolved, being sought on the basis companies cease to carry on business. So it was clear that it had gone into liquidation. In fact, the petition in fact pleads the liquidation. But it was specifically not put on the basis it had been dissolved, and that is continued at the next page of the transcript, page 47 on the next page. I'll just invite you to read the underlined bits. And it's on the basis of how the case was put, but if we then go to the judgment of the Deputy ICC Judge, paragraph 92.
Sorry, paragraph?
92. Yes, paragraph 92. In relation to the first ground, Ms. Hilliard told the court petitioner was not claiming a sub-fund had been dissolved. According to the first category, right law was a sub-fund to cease to carry on business. So it was a quite deliberate decision made not to pursue the dissolution route. And in fact, she'd said at paragraph 31.7 of her judgment, the judge's judgment, go back to that, about Ms. Hilliard's submissions. It's irrelevant that sub-funds already been subject to a voluntary winding up process. This is page 104 by the directors. As there's no provision in the OD or the articles to the effect that upon such winding up, the sub-fund is dissolved. But this is not surprising since dissolution is normally associated with incorporated entities. So it was clearly before the court that the company had been subject to a voluntary liquidation process. The sub-fund had. A deliberate decision to be made not to plead or to proceed with the dissolution route, and that's why, although I don't want to take this as a sort of deep pleading point, it actually is a further example of the way in which the appellant's case has evolved significantly over time. But now dissolution is seen as a basis for the court's intervention under ground 3, which had never previously been a separate freestanding ground, when the petition quite deliberately was not put on that basis. And the trial didn't.
Permission was granted on ground 3.
It was, but not on the basis of dissolution. It's. I won't take it further, other than it is a fact that this is a coming.
Have you been inhibited from arguing the point?
Well, I clearly I understood the case would be as it was put previously, but
have you been inhibited from arguing?
I won't take it as far as that, no, my lady. But I do say that the court has to impose some sort of discipline where they, in any event, have the case has moved in so many ways all the way through. I don't know if there's any further I can do to assist.
Can I just, sorry, I just want to get, I understand you make a point about dissolution. Can I just check what, you've just shown us that the petitioner put to the Deputy ICC Judge, not that the sub-fund had been dissolved, but that the sub-fund had ceased to carry on business, right? Yeah?
Yes.
So just, for this we have to suspend, you assume we're against you on your point that the sub-fund isn't an association, etc., etc.
Yes.
I understand all those points. We're at the tail end of the argument here. The argument was put to the ICC judge that the sub-fund has ceased to carry on business. And the ICC judge says at page 125, as shown from my decision under the previous heading, I don't accept this argument. What did she mean there? Why did she say that the sub-fund hadn't ceased to carry on business? Where did she say the sub-fund had not ceased to carry on business? She said that the petitioner wasn't a contingent creditor, but that's a different point.
I wonder if I could have a chance to try and look at it through, perhaps while my learned French considering. I don't know the answer on the spot.
Because I mean, you may be right. Assuming you're right for a minute that, and I'm getting ground 3 of the grounds out, but you say the petitioner can't rely on 2215A that the company is dissolved. But why can't they rely upon the company
cease to carry on
business?
I'm not saying that they can't rely upon that ground.
So if all other things were equal and we got to this stage, and I appreciate you say that's a long way to travel, but assuming we were at this stage, this would be on the basis that the sub-fund was an association.
Yes.
And either they had locus as a contingent creditor or a contributory as defined, or that the Russian bank authorities indicated that you could, in an exceptional case, simply apply this section on behalf of the person interested. Are you saying that they couldn't say that any of the grounds made out in 2215A are satisfied?
No, what I was trying to explain was they were saying there were the special circumstances which would justify the Russian bank approach being adopted occur where a foreign company has been dissolved. So my point was, if they're saying there is this very narrow exception that only applies or applies to where a foreign company has been dissolved, it then becomes material that they chose not to petition on that basis.
Okay.
That was the point I was trying to make. Why I took this pleading point.
Right. So that, but
please don't be so offended about me referring to it as a pleading point. It was a shorthand. I wasn't being offensive.
No, I took it because if as I understood from their supplemental skeleton, they were saying that brings this case within that allegedly narrow exception. That is a further change of case, and a deliberate choice had been made not to go down that route before. So a question, I suppose, Lordship, would be, would that, but the alternative ground of ceasing to trade, that would be a further extension of the Russian bank cases, if there is such an exception, from dissolved foreign company to a one that has ceased to trade, and that would not only give life to that exception, alleged exception, but it also would then expand it.
Thank you very much, Mr. Lightman. I don't know, did Mr. Kaplan want to carry, was he following on? Mr. Kaplan, were you following on?
No, my lady's not order. Nothing further as well.
No, thank you very much indeed. Any reply?
My Lord, yes, quite briefly. If I can just begin by addressing the central question in this appeal, and that is, if this is an association, what are the participants in that association associates in? They're associates of what? Are they shareholders of the fund, or are they associates of the sub-fund? That seems to me to be the critical question on first ground. And to that we say this. We say, well, first of all, look at the way that this is structured, and look at the indicia, we say, of association. First of all, you have investors bound together by a set of rules that applies to the sub-fund. You have assets...
Sorry.
Yes.
Bound together by a set of rules that apply to is bound together by the articles.
Yes.
With the articles are an agreement between them and the fund. True,
but making specific provision as to how it is that the I'll say dedicated fund because that's how they refer to it in the articles, but how the sub-fund is to be run. What I'm going to do in a moment, my lords, I'm going to take you to just two provisions in the articles which I say make this point.
Yeah.
The second point is, if you like, the WhatsApp point my lord made earlier. There are assets that make a liquidation a productive process in this case. And thirdly, the investors, including the appellant, have a right to distributions from the realisations that come as a result of those assets. So we say on those three bases, we have all the indicia of an association. Before looking formally at what it is that the Articles of Association say, what I would ask the court also to do is to consider it this way. In an umbrella structure such as this, you have it appears from the papers, a huge number of different sub-funds within that structure in which different people invest, all for different purposes and on different terms. To what extent do the participants in sub-fund A and sub-fund B have anything in common in terms of shared interests? Absolutely nothing, we would say. Whereas if you look at the investors in this sub-fund, there is commonality of interest between them because you're dealing with a single pool of assets and a single right to distribution. And I think I can make that point by reference to what the articles themselves provide. And if I could ask your ladyship, your lordship, to go to, this is the supplementary appeal bundle. If you would,
Thank you.
And first of all, to divider 22, page 211. And just before we look at this, the point's been made by the court already that the way these documents are drafting between the offering document and the articles is highly unsatisfactory and full of inconsistency, but actually this is the Articles of Association, what one might take as being the operative document of the relationship between the investors. Article 8.1a, relating to the issue of shares, Board of Directors may issue shares of any class or category within each separate dedicated fund.
What does that mean?
My lord, the point I'm coming to that.
There's something missing, there's something going wrong there. You don't issue shares within a dedicated fund on any view, because the dedicated fund is a fund of assets. I mean, it means the board of, if I was to pass it out, it surely means the board of directors may issue shares of the fund reflecting or which relate to each separate dedicated fund.
Yes.
In different classes which relate to each separate dedicated fund.
Yes, and I don't depart from that interpretation of that article. The point I'm making is this: here you have a situation where you have shareholders in the fund in respect of each of the investors, but their rights between each other and what they're entitled to are separate in terms of their participation in the sub-fund. And what I was going to take the court to was, as I said, looking at the indicia of association, one of the indicia would be a right to a share of whatever the surplus is in any liquidation of the association. And that is what's provided for in Article 16.2e. If I could ask your ladyship and your lordship to turn to that, that's page 227. General meeting, or as the case may be, the liquidator it has appointed, will realise the assets of the company or of the relevant classes, categories and or dedicated funds in the best interest of the shareholders thereof. And upon instructions given by the general meeting, the depository will distribute the net proceeds from such liquidation after deducting all liabilities, costs, liquidation expenses, amongst the shareholders of the relevant classes, categories and or dedicated funds. So I quite accept there's membership of the fund, but when one looks at what in substance that involves and what the articles provide for in terms of the relations between the members, the investors of the individual sub-fund, you have a self-contained structure where those individuals have far more in common with each other in terms of their shared interests than any interest in any of the other funds that exist, sub-funds that exist within the fund. Then that's all I intended to show the court in terms of the first point. The second point I'll address quite briefly, which is the exceptional jurisdiction point.
Yes.
And there were a number of things that my friend said which I do not agree with. The first of which was that the first time the point about dissolution has been taken is in the supplementary skeleton argument we filed 2 weeks ago. In fact, one can see from the judgment, it's page 87 of the core appeal, paragraph 81, which I think if you were referred to, you were referred to...
Paragraph 81?
Yes, paragraph 81.
Thank you.
Page 87, paragraph 81.
I have it, thank you.
It's described under the heading, the appellant's alternative position. So this is something we argued on appeal before Mr. Justice Richard Smith. And you'll see references made there to the Russian English bank case and the jurisdiction to do so where the debt has been disputed or where a foreign company has already been dissolved. So we've been making this point, and there hasn't been a pleading point taken against us in respect of it either. What I would say about the pleading point is this issue of dissolution, it comes from the fund's own evidence in these proceedings. We have referred to the relevant section that deals with dissolution in the petition. We haven't said dissolution by name. I suspect the reason for that, and what Ms. Hilliard was referring to at first instance before the Deputy ICC Judge, was the fact that perhaps dissolution is inapt to apply to a structure such as this, because one's not thinking of it, we never contended it was a company in the usual sense that was capable of dissolution. But in any event, we've taken the point, we've referred to the Russian English bank case, and we say, in any event, we've referred to the relevant section of the petition and read sensibly. We say it's open to us to argue this point. In any event, the exceptional jurisdiction exists, and we say if it ceased to trade or has been in liquidation, there's no reason really to treat that as differently from dissolution. On the authorities my own friend refers to, finally, I think there are 2 points that the appellant would make. First of all, on the authority from his more recent one, the Baker Hughes case. Now, I don't think your ladyship may turn it up, but it's at Divider 6. I don't think this authority says anything that's in any way surprising in the context of the argument that we're having, which is my learned friend referred you to paragraph 10 and referred at the end to the averments regarding the possibility of assets being restored to the company are in any event in the most vague, provisional and general terms, and suggesting that the appellant's in a similar position to the petitioner in that case. Well, one only needs to turn to the previous page and paragraphs 6 and 7 and see that that is a case where the respondent had joined issue with the petitioner as to their standing as creditor and was in the process of, for example, one can see from the end of paragraph 6, putting forward a case, obtaining an Algerian lawyer's report, and engaging with the issues on the case and engaging with the standing of the petitioner as creditor. That's, we say, what's not happening in this case. And it's that lack of an explanation, obviously, that we rely upon for the contingent creditor point as well. Then finally, the GFN case for which the court has taken. We say that case has to be used with second article and supplementary second in the context of this is guidance in respect to if it helps, it's divider 11 and the conclusions begin on page 228. We say this case is dealing with the ordinary situation, which is a creditor's petition to wind up on the basis of the inability of the company to pay. And what the decision doesn't do, as subparagraph F, paragraph 94 makes clear, is stray into the exceptional jurisdiction for which we rely under ground 3 of RP. And that is also apparent over the page at paragraph 96, where it said, I do not think these cases, referring to the Russian bank cases, can be a precedent affecting the ordinary winding up situation where a petition is presented by a creditor with a disputed debt. And our submission, the appellant's submission to the court is that this is a petition that's very far away from the ordinary situation. Unless there are any other points you wish to make.
Just one question.
Yes.
225. Assuming you're, for all other purposes, within the scope of 225 on the basis of cessation of business, assume we've got to the argument, you've won on subfund.
Yeah.
We're looking at this on the basis of cessation of business by the subfund. And it's an exceptional case where you don't seem to have any other means of getting a remedy or without a winding up order. Mr. Lightman says two things. One is you still would have to fit within the definition of creditor or contributory under section 124, which I don't think we've got in the bundle.
I think it is. I think
Is
it
it
is.
just in
an
I have to say this is a point that's been taken quite late. It's in Mr. Lightman's supplemental.
It's divided 16 of the main authoritative bundle.
All right, thank you.
It's something that's
Oh, there we go. Yep.
dealt with in the skeleton article.
Okay. Well, he says you, in order to fit, you have to fit within creditor or contributory, and he says, well, if you fail to establish you're a creditor, including a contingent creditor, under ground 2,
Yeah.
which again is the hypothesis we're on, he says you're not a contributory either, therefore you just can't, no matter how exceptional the circumstances, the court can't make an order under 2251. That's how I understand the argument.
Yes.
So assume we've got to this stage of the argument. We can't say you're a contingent creditor because we don't have any sufficient evidence about what might come into this liquidation of the sub-fund. but it's an exceptional circumstance in which you're left without a remedy otherwise for what seems to be the unexplained disappearance of a large sum of money
Yes.
invested in this sub-fund. It would all, Mr. Lightman says, turn on the fact that you're not a contributory, and he took us through the definitions of contributory.
I think a few things. First of all, my lord, I accept the restricted meaning of contributory when it's used in this context, in the context of section 124, which is someone who's required to contribute to the assets. I accept that. I have to say this is something that wasn't foreshadowed. So I think I said earlier in response to questions that my standing for the purposes of ground 3 didn't depend, and I think your ladyship asked me that question.
Yes.
I said that because I hadn't heard Mr. Lightman on this issue, so it's something.
Of course, he's now saying they are. It is dependent.
Yes, and I understand that to be the case. But I was not ready for that point being taken. But there it is. I can deal with it. So I accept. I think. Well, no, I do accept that for these purposes we would have to be a creditor. What I don't accept is that we have to establish our status as creditor on the balance of probabilities for the purposes of the proceeding. We say it's sufficient, based on the Russian bank cases, for us to say there's a basis for saying we're a creditor and therefore for having an interest. The court can't resolve that interest now, and therefore we ask the court not to resolve that interest now, but to allow the petition to proceed and winding up all to proceed. In circumstances where this is a situation where the court's dealing with a respondent to a petition which, on the responsive evidence, no longer exists.
So, okay, I'm just sorry. Can I just go back a bit? What's the jurisdiction to wind up on the just and equitable ground?
I think we'd have to be a.
The court can make a winding up order on the basis of the just and equitable ground. That's section 1221F. From memory. I don't think that's one. Probably is in some weird place.
That is. I don't know why it's not.
It's one of the grounds for the winding up of a company is a just and equitable ground.
Yes.
Right. I should have brought mine. I think it's 1221F, is it?
One was actually G.
G. There we go. Sorry, that's old age for you. So 1221G.
Yes.
Okay, so you just and equitable. But but that's still covered by 124 application for winding up, yeah? It's still, that's the way it hangs together. 1221G says these are the grounds on which you can make a winding up order. But the application is still under 124, yes?
Yes.
Now, if contributory meant what Mr. Lightman says it means, you only can petition for a just and equitable winding up on the basis that you are contributory, liable to contribute the assets. I don't think it can be as simple as that, because people who have fully paid shares in a company and therefore are not liable to contribute in the sense that there is nothing unpaid on their shares can plainly still contribute for just and equitable winding up. You know, minority oppression and all that.
Yes.
So it can't have, and I think there's a lot of learning on this.
Well, there is. I think the situation is slightly different under the Companies Act, obviously under section 994 petition.
Yeah, no, forget 994 for a second, but people petition under 994 unfair prejudice, or in the alternative for just and equitable winding up. I mean, you're discouraged from doing that if you should be generally choosing one or the other, and you can't make a just and equitable winding up order if there's another remedy. But that's not my point. Sorry. The point is that somebody with fully paid shares can undoubtedly petition for a just and equitable winding up using section 124, even though they are not liable to contribute to the assets.
Yes.
Save because there is nothing unpaid on their shares. They have fully paid their shares. And so I don't think it can be quite as simple as Mr. Lightman. I think what Mr. Lightman was suggesting was that because your clients didn't have any further contribution to make in a winding up, they weren't a contributory, ergo they can't use 124. And I just wanted your answer on that.
May I?
And it may be that it's taken you all by surprise, and we ought to allow you to put in deal with it with a bit of thought. But I think there's quite a lot of learning on this point.
There is, my lord. I certainly was in one case involving that issue, but it was in the context of 994. The difficulty that I face, that I accept I face in the context of the Insolvency Act, is Section 79, which we obviously don't have here. But section
We do.
We do.
we do. Do we?
We have it
It's in the little extra bundle.
Oh, right.
at tab 8.
You see, I have a feeling that 79 is not interpreted to mean liable to contribute in the sense of having unpaid shares. Because otherwise that would, in every case, including, the winding up of normal companies on the just and equitable round, mean that somebody with fully paid shares can't seek a just and equitable
Yes.
winding up. And that just can't be right.
No.
Well, it isn't right. And so that's why I think there's something slightly more to Section 79 than meets the eye. But
I think I have to accept, my lord, at the moment, I can't assist the court further on that issue. I know there is case law.
yeah, I mean, your status as a shareholder of the fund, and I assume for this argument, all the other things are in your favour and against
Yes.
Mr. Lightman. That's the basis of this. You're not required to contribute any more.
No. As far as I think that must. I think I have to accept.
Your shares are fully paid.
Yes. Yes.
But so it would all come down to the question of how do you interpret 79 in the context of locker standi to seek an order?
Yes.
In relation to, for example, the just and equitable winding up of a normal company, and ergo 2215.
I appreciate. The court's had a lot of written submissions on this already. This is a point which I'm afraid I am unable to address today. I'm slightly, because this hasn't been in written submissions from the fund before.
I was going to invite Mr. Lightman also, because he's not been asked about how the just and equitable provision ties into all of this.
Is that something that we might submit very short written? I think it probably is quite a short.
Mr. Lightman?
Again, don't want to make a pleading point, but the petition's put on the basis that the petitioner is a contingent creditor. It's never been put on a basis that it's a contributory. But I didn't envisage I was saying something radically new, because it hasn't been. It always put its case as a creditor. Initially, it was a creditor, then a contingent creditor, never as a contributory. And so
I can see your difficulty, but perhaps Honourable Justice Snowden could crystallise the actual point that the pleading point's coming from my lord. On
yes, I am certainly extremely happy. All I really was saying was I wasn't seeking to sort of raise a new point. It was just, well, it's clearly not a contributory because that's not how it's put. How it's.
I understand that, but I think my lord was wanting to see how the just reasonable option would fit into this, and so I wanted to give each of you an opportunity, if that's a matter which is causing concern to him, to respond to it. But I thought it would be easier for each of you to respond to it shortly in writing later, when you've also had the benefit of discussing it with your junior. But also, if my lord felt able just to crystallise precisely what he'd like you to deal with.
Let me try and deal with it. As I understand it, the argument which is put is that under section 2215, that section 2215 cannot be invoked by anybody who is not a creditor or contributory because of the wording of section 124. Sorry, it's in a strange place and I've lost it again.
Looking for
141.
124, I think it's at 16.
Yeah, nice.
That's 16.
Yeah, thank you. Thanks. So, the argument, as I understand it, is that you can only invoke the provisions of ask the court to make a winding up order on any of the grounds in section 2215 if you are a creditor, including a contingent or prospective creditor, or contributory within the meaning of section 124. Mr. Lightman says the only basis on which this petition was put forward was on the basis that the appellant is a contingent creditor, and they're not. And we've heard all the argument in that respect. The question that I had, which followed from that, would be, is it possible that the appellant is in fact a contributory, such that if permission to amend the petition was given, the court could, if it thought otherwise appropriate, make a winding up order under section 2215. Now, I appreciate that that is not the basis on which the case has hitherto been put, and that it would involve granting permission to amend the pleading, but on the other hand, if the petition were dismissed, another one could be presented and we might end up back in the same place. But the question is therefore, is assuming everything else being equal, is the appellant a contributory? My understanding is that Mr. Lightman points to section 79 and says no, because contributory is defined as meaning a person liable to contribute to the assets in the event of it being wound up. Mr. Lightman says there is no evidence or no suggestion that if this sub-fund were wound up, the appellant would be liable to contribute anything to the sub-fund. And that's as far as I think the argument we have heard has gone. And it was that, and Mr. Lightman can correct me if he thinks I've misrepresented what he said, I think that's what I've understood he said, and that's the question upon which I was inviting you to comment. Bearing in mind all the points about it's not the way you previously put it, etc., etc.
I won't.
But it's the narrow point about whether your clients could claim to be contributories within the meaning of section 79 or within the meaning of section 124 as forms the basis for 2215. I hope that's...
My lord, thank you, that's clear.
Is that clear to both
Very
of you?
clear.
I should say all three of you, Mr. Kaplan, online.
Yes.
I think Mr. Lightman, seeing the way that this has emerged, I think that I'll ask each of you for short written submissions. I think unusually actually for post-hearing submissions, I'm going to ask you, Mr. Lewis, to go first,
Yes.
so that you have an opportunity, Mr. Lightman, with Mr. Kaplan, just to see precisely how the response to that, and then you can respond.
Very grateful.
But quickly, please, before everyone. I mean, this is a complex case, and we've darted all over the place in it. And I think certainly for my part, I'd be very grateful to have it before I've got engrossed in something else completely different.
Well, my lady, if you tell me when it will be done.
No idea what day of the week it is. Wednesday, is it Wednesday?
Yeah.
But next Monday, how would that
Yes.
be for you? And
Monday's
Wednesday
bank
for you,
holiday.
Mr. Lightman? Oh, it's bank holiday. I apologise. Tuesday,
Tuesday.
and then Thursday.
could we have Friday? Just in case we do have to look at this a bit further. Be grateful.
I'm grateful.
Anything else?
There are no other submissions from you.
I'm very grateful. Anything else? No. Thank you both very much. And Ms. Putnam. Well, thank you all very much indeed for all your submissions in what was identified as being a difficult appeal when permission was granted, and we're very grateful for your extensive and detailed submissions, however they've come about. You won't be surprised to hear that we're going to reserve our judgments. I can't tell precisely when they will come. They certainly won't come before the end of next week. We will send out our draft in the normal way. For typographical and minor errors, please, not as an opportunity to re-argue the case. And I now remind you and ask each of you to remind those that sit behind you and your lay clients, and particularly in your case, Mr. Lewis, members of the local authority, of the terms of the embargo. And please make sure that you don't find yourself in the position where 19 people in the local authority say it's absolutely essential they see the draft. Because it's only our final versions that should be distributed. So I'd hope we can deal with all the matters in writing thereafter. If there's any dispute as to costs and everything, we'll deal that on paper. I think your solicitor's got a question. No? Unless there's anything else we can usefully do.
No.
No, thank you all very much, and thank you those sitting behind for all the assistance you've obviously given counsel in